A SPAC investment ought not be considered any more dangerous than participating in any other first public stock offering by a business, and shareholders should therefore be subject to the same safeguards as they would be if investing in any other initial public stock offering by a firm. In the event that they do have a particular firm in mind, they often keep that knowledge a secret until after they've purchased the company. But this frequently results in a great number of issues both before and after the merger has taken place. However, there was one case in which a legal firm that was a part of the Lucid merger was believed to have been left out of the agreement for some reason. There was some uncertainty in the deal, but Lucid did not want to become involved in it. What was the specific nature of the case? What caused it to go ignored for so long? And more importantly, is it settled now or not? All this is to come, so stay tuned. Welcome back to NewVehicleMedia, your go-to channel for EV stock. Quick reminder, subscribing's free, and liking the video helps YouTube suggest similar content. Comments are loved and featured in upcoming videos. Dentons, a white shoe law firm, filed a lawsuit against Lucid in Delaware after the business went public while merging with a blank check company. The lawsuit stated that Dentons was wrongfully excluded from the agreement. Investors should be alarmed by any lawsuit filed against a newly minted public company, particularly one from a well-known worldwide legal firm like Dentons, which most certainly has some individuals inside its firm to call on for legal guidance concerning compensation involving the issuing of shares and the transfer of shares. Lucid will not be able to sweep this problem under the rug. If this is the case, it indicates that there's an issue with the company's culture, and it would certainly not be a good thing. The lawsuit, which was highly classified, was filed in Delaware Chancery Court and accused Lucid of declining to interfere in attempts by a Seychelles-based business, Pisces, to sell or transfer Lucid shares that were restricted by the law company's financial and security obligations. After Dentons won rights to the shares in an initial court battle, it also targeted Pisces, which was reportedly founded by an unidentified party to hold the shares. Those finer details were blurred out in the modified lawsuit. Nevertheless, securities papers filed as evidence seem to show that Pisces is associated with Shanghai Qicheng Yuming Investment Partnership Enterprise, a Chinese business that Dentons represented in a lawsuit against Jia Yueting, the founder and former CEO of Faraday Future, another electric car manufacturer. So that raised some questions about the reliability of the lawsuit. In the meantime, there was no way to get in touch with Pisces since no contact information was available. In the highly classified lawsuit, Dentons asked the Delaware Chancery Court to compel Lucid to release a new certificate for the stock, record Denton as the holder of the equity in Lucid's books, and restrict the shares from being transferable without their approval. Additionally, Dentons requested that the court halt any further transfers of the shares while the lawsuit was still ongoing. There was no quick response from Dentons' lawyers or officials to questions about the matter. Neither did Lucid's executives. Then, lawyers for Shanghai Qicheng Yuming Investment Partnership Enterprise got shares in the company in exchange for their help with the dispute over a Chinese arbitration ruling. Those shares provided Dentons with a position in Ativa. But in a statement, Dentons said that the shares were purchased from a business identified as Pisces. Dentons claimed that Pisces had breached its contractual responsibilities by refusing to conclude a share transfer agreement. Specifically, the lawsuit states that the business, quote-unquote, requested the court's intervention in order to defend its financial and security interests because the shares were changed to Lucid shares after the merger was completed. Lucid Motors has now reached a settlement with Dentons based on the allegation that it had been unfairly excluded from the transaction. A week after the parties negotiated an agreement to transfer almost 1.75 million Lucid shares to Dentons from Pisces, where they had been frozen by a previous court order, Vice Chancellor Joseph R. Slites III dismissed the matter from Delaware's Chancery Court. Slites said in his ruling putting the agreement into effect on January 18, 2022, that the remainder of the Lucid shares owned by Pisces should continue to be held in Pisces' name. Businesses, particularly tech companies, are often subject of legal action. However, the majority of the time, the lawsuits concern the licensing of technology. It's unusual to see a renowned law firm file a lawsuit against a publicly traded corporation in order to get reimbursed for services provided. This wasn't the first time the startup has had to deal with legal issues. Winston Cooks, in conjunction with the Beeman law firm, had also filed a proposed securities class action lawsuit against them. They joined at least 6 other law firms that have opened class action lawsuits against Churchill Capital and Lucid in the last year for the same reasons. These law firms were Labaton Socorro, Frank R. Cruz, Rosenlaw, Thornton Law, Bronson Guritz and Grossman, and Clancy Pronge and Murray. Many of these law firms were looking for individuals who had suffered losses after buying shares in Churchill in the expectation of the companies acquiring and merging with Lucid, which was projected to produce thousands of vehicles last year, thus producing a lot of money for the SPAC Churchill. The SPAC took a significant stake in Lucid before Rawlinson said that the business would be manufacturing thousands of premium electric automobiles by the spring of 2021. The lawsuit even said that the Lucid CEO promised that the firm would be producing thousands of the Air automobiles at their brand new Casa Grande factory, enticed shareholders to acquire Churchill equity. These kinds of comments caused the stock price to rise before the SPAC announcement was even made. Investors with foresight were unlikely to want the legal firm to meddle with the company's long-term prospects. Although some may argue that it was an unnecessary distraction, it happened around the time when Nikola Corporation and Lordstown Motors were under fire for failing to be transparent with investors. Essentially, they serve as sobering reminders about what may happen when public business management and boards of directors play fast and loose with the facts. But as always, I'm curious to hear what you think of these cases, especially when it comes to the idealistic rhetoric of SPACs pre-merger. Do you think it's misleading? Or was it just the pandemic that produced a shortfall of supplies for the firm, resulting in certain delays? Let us know what you think by leaving a comment down below. Lucid recently had a recall of some Lucid Airs. Mr. Uber says if this was any other company, they would have done everything not to recall it, but Lucid is an honest company that wants to provide good quality vehicles, and when there's a supplier issue that's causing their vehicles to be less than optimal, they did what was right. Good for Lucid. That should wrap things up for today. Keep in mind that subscribing's still free, and liking helps YouTube recognize your preferences. Thanks for taking the time to watch, and I look forward to seeing you in the next one.